In recent times, you must have come across the term sedition law in mass media, magazines and newspapers. The biggest question is sedition an anti-national act or an anti-government agitation? Recently, the Supreme Court protected a political leader and 6 senior journalists from arrest in multiple sedition FIRs, first information report, registered against them. Sedition is a crime under Section 124A of the Indian Penal Code, IPC. Section 124A IPC defines sedition as an offence committed when any person by words, either spoken or written, or by signs, or by visible representation, or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India. Disaffection includes disloyalty and all feelings of enmity. However, comments without exciting or attempting to excite hatred, contempt or disaffection will not constitute an offence under this section. The public debate over this issue was reignited recently when a 3-judge division bench of the Supreme Court said in an order on May 31, 2021, in the case of MS Amora Broadcasting Company Private Limited and R.V. The state of Andhra Pradesh and Odisha is other stated that there is a need to define the limits of sedition. Following, a 2-judge division bench of the Apex Court, in the case of Vinod Dua vs Union of India and Oz, quashed an FIR against the petitioner, journalist Vinod Dua, for the offence of sedition. In its judgment, the court made an observation that every journalist shall be protected from the charge of sedition, taking into account the interpretation of the offence as propounded in the court's landmark judgment in the case of Kedarnath Singh vs State of Bihar. Sedition laws were enacted in 17th century England when lawmakers believed that only good opinions of the government should survive, as bad opinions were detrimental to the government and monarchy. The law was originally drafted in 1837 by Thomas Macaulay, the British historian politician, but was inexplicably omitted when the Indian Penal Code, IPC, was enacted in 1860. Section 124A was inserted in 1870 by an amendment introduced by Sir James Stephen when it felt the need for a specific section to deal with the offence. One of the most vehement critics of the sedition law was K.M. Munshi, who argued that such a draconian law is a threat to democracy in India. It was one of the many draconian laws enacted to stifle any voices of dissent at that time. Sedition is a non-bailable offence. Punishment under the Section 124A ranges from imprisonment up to 3 years to a life term, to which fine may be added. A person charged under this law is barred from a government job. They have to live without their passport and must produce themselves in the court at all times as and when required. The SC highlighted debates over sedition in 1950 in its decisions in Brij Bhushan vs the State of Delhi and Ramesh Thapar vs the State of Madras. In these cases, the court held that a law which restricted speech on the ground that it would disturb public order was unconstitutional. The case of Tara Singh Gopi Chand vs the state was the first instance of a court in independent India adjudicating on the constitutional validity of Section 124A of the IPC. In July 2019, Nityanand Rai, Minister of State for Home Affairs, told the Rajya Sabha that there is no proposal to scrap the provision under the IPC dealing with the offence of sedition. There is a need to retain the provision to effectively combat anti-national, secessionist and terrorist elements. The word sedition is extremely nuanced and needs to be applied with caution. Due to its poor definition, sedition law can be used spuriously by the police to falsely accuse individuals, as it does not clearly state which acts are seditious and provides a broad outline of what can be classified as seditious. The sedition laws have empowered the executive branch of the government to use the ambiguously defined provision as an instrument to regulate public opinion and indiscriminately wield power. Section 124A should not be misused as a tool to curb free speech. The SC caveat, given in Kedarnath case, on prosecution under the law can check its misuse. It needs to be examined under the changed facts and circumstances and also on the anvil of ever-evolving tests of necessity, proportionality and arbitrariness. There are growing instances to show that this law has been weaponized as a handy tool against political rivals, to suppress dissent and free speech.